Here's the latest from Capitol Hill. Senator John Kennedy questioned 4 district judge nominees, LaCour, Maxwell, Chamberlin, and Lewis, on constitutional interpretation and judicial philosophy. Topics included the rational basis test, notice versus fact pleading, and Brown v. Board of Education. Judge LaCour faces questions from Senator Kennedy about the rational basis test. LaCour explains it's the least stringent standard. Laws need only a rational link to a legitimate government interest.
Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, that sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic, it's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that is interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Kennedy asks what happens if the legislature doesn't state a reason. LaCour says courts use plain meaning and precedent, not inventing reasons, but interpreting statutes under existing law. Kennedy presents a hypothetical. Suppose a law lets college graduates skip the driver's license test. What constitutional test applies? The nominee answers, rational basis, since no fundamental right is involved. Kennedy presses further, but the nominee cites Supreme Court precedent for this approach.
Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
So what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems in America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
Senator Kennedy asks Judge Chamberlin about the difference between notice pleading and fact pleading. Chamberlin struggles, linking notice pleading to due process and jurisdiction. Kennedy presses, what system does the federal judiciary use? Chamberlin eventually answers, fact pleading. This exchange shows how judicial nominees face tough scrutiny on procedural law.
What system does the federal judiciary use? Notice or fact?
No, fact.
Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed. a lot of-
14th Amendment was later.
It was later. It was a
Can you turn your
reconstruction.
microphone on, please?
Sorry
Thank
about
you.
that.
Senator Kennedy asks Judge Lewis how judges should interpret the Constitution. Lewis supports an originalist approach, using the public meaning at the time it was written. Kennedy challenges this with Brown v. Board, questioning desegregation under originalism. Lewis insists Brown was correct and that separate was inherently unequal.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time, I say, okay, it seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case-
the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but
Senator.
okay, I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Senator Kennedy tests nominees not just on legal knowledge, but on their ability to defend judicial reasoning under pressure. Every answer reflected the tension between theory and real-world application. Like, subscribe, and turn on notifications for more updates from Paralegal America.